Adjournment request, if any, from item number 1 to 8.
Lordship, with respect to item number 3 and 4.
3 and 4.
Lordship, unfortunately, I have lost my brief. I have to reconstruct, maybe taken up next week, Lordship.
My lord, I'm appearing for the opposition. I'm an outstation counsel. This matter has been adjourned 13 times
13.
by the appellants. And on
Lordship,
the
Lordship.
last occasion, this matter was specially fixed in the 4th week. So I've come. And in fact, one of the appeals, item number 3, it is barred by the litigation policy. So
Lordship,
I'm not even sure what is to be argued.
Lordship, with reference to my learned statement that 13th time it has been taken by me. Lordship, kindly please to see the order sheet, Lord, for whose default has been taken.
I can read it out.
Unnecessary, Lordship.
Don't enter into this blame.
And
game.
Lordship, I informed the local council on Friday itself that I have lost my brief.
My lord, on the previous occasion when the matter was
What's
taken
the
up,
problem?
Lordship, I have misplaced my brief. I have to reconstruct my brief. Maybe they can next week, Lord. And I ideally informed the local council on Friday itself, Lord. And the case was listed on 5th. Adjournment was taken on by my learned friend, local council. Lord.
it was specially fixed. But
No further. This is unfair.
it's not.
What to do then? He is not having his.
My lord, there's at least one appeal which is covered by the litigation policy.
Whatever it may
Very
be,
well, ma'am.
consider it.
Very, in that
Time of
case, I'll be very grateful if your lordship can kindly keep it in the 3rd or 4th week so I can book my tickets in advance.
3rd and 4th.
Any day in the 3rd and 4th week of this month, so I can book my tickets in
Okay,
advance.
give us the date.
19th, my lord?
19th of September.
Yes, this month. Very good.
Then council must submitted that due to some unavoidable circumstances, he is not able to prepare the case. Stop, he pays for an adjournment with the consent of the parties.
Okay.
This matter of 19th September. However, 19th of September with misunderstanding that no further adjournment shall.
Very good.
May please, your lordship, I beg to mention item number 2. This matter may be kindly passed over for the day because Mr. S. Chakraborty is out of station.
हम लोगों ने किया है
Password for the day.
Can it be on 5th of September?
5th of September.
5th of September. Oblige me.
From item number 9 to 14,
May I please,
9 to
your
18.
lordship, I beg to mention that item number 7, my lord. Matter may be,
7.
yes, my lord. Matter may be adjournment for the day.
What is the matter about?
My engaged counsel is some personal difficulties, so.
No, what's the matter involved in this?
non-judicial stamp paper dispense करते हैं non-judicial stamp. It's a matter of non-judicial stamp paper.
Yes, 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 my lord.
I think so now it's more than a year. Each time. It's time to make it clear. It's 6 weeks.
7 and 8.
May I please, Lordship? Lordship, I beg to mention item number 10, Lordship.
Yeah.
Lordship, conducting counsel, Mr. A.R., we could not able to present today, Lordship, due to health issues, Lordship. So, Lordship, pass over the matter for the day.
So,
I oblige, Lordship.
yes,
May I please, your lordship? Lordship, with the consent of the opposite side, beg to mention item number 9. The matter may be adjourned for a day due to some personal inconvenience of the conducting counsel.
please for the other side.
We have took the consent.
May it please your lordship. Lordship, I'd like to mention item number 11 and 12 for adjournment, lordship. My senior,
11 and 12.
yes, lordship.
My lord,
I've already informed the other side.
my lord, after 1 year it has come, my lord. My lord, let it be on Tuesday, next
So why
Tuesday.
you have consented then?
Huh?
Why you have consented?
No,
for
no, I am
Tuesday?
not consent. I am not given consent.
He did yesterday, lordship.
No, no, no. Oh, I am- Tuesday, Thursday, yeah. Thursday. Fifth, bro. Fifth September. 5th September. Okay.
No, I think it's okay. इसकी बात का होगा उसके बाद।
My lord, it may be-
डीम्ड यूनिवर्सिटी में AICTE ने ऑर्गेनाइज किया। इसकी इसमें मैंने लिखा नहीं होता है। Nomenclature के मुताबिक AICTE के मीनिंग बोला कि बैचलर ऑफ साइंस जैसे BTech कोर्स है इस
My lord, 5th September, 5th September.
सितंबर
My judgment.
Will you go?
Maybe the lordship, item number 15, lordship, we have circulated an adjournment slip, your lordship. May I please the matter make of the 4 weeks, your lordship.
yes
We have circulated an adjournment slip, your lordship. On Friday night,
you have
on Thursday, your lordship.
you have been informed the other side
We have informed lordship, we've taken.
Arjun.
Lordship, I'm appearing on behalf of Mr. B. Purkat, Lordship, in item number 16, Lordship. That may be come after 1 week, Lordship.
After
1 week, Lordship. Item 16,
1 week
1 week. All Lordship, tomorrow is similar matter is fixed in item 26. That may be take over in item 26, Lordship. Tomorrow's list, Lordship.
tomorrow
Irritable 5 public 2024.
tomorrow you mention make a mention tomorrow.
Right, Lordship.
My pleasure, Lordship. What should I beg to mention item number 14, my lord? I have taken the concern, I am appearing for the appellant, my lord. And my senior Mr. S. Tamaria, my lord, he is out of station due to some medical issues, my lord, of his brother, my lord. Elder brother.
Electricity. Yes, what do you want?
Lordship,
What do you want?
Lordship, it may come up after a week, my lord.
Arjun.
My lord, I'm obliged. My Met with your lordship. Lordship, I paid for listing of a matter, Itapil lordship, which was filed on June
What
19.
about the matters listed today? Listing of a matter, nobody is dealing for that.
Lordship, this Itapil was filed on 19 June, but till date, this has not been listed.
Why? What happened?
I'm,
Have you inquired from the
yes,
registry?
I have inquired, lordship.
Then what happened?
No
What
defect
the-
is there, nothing is there. Similar to other Itapils were also filed together. Those were listed, but this matter has not been.
Next week.
Obliged.
Next week.
Supplementary list for orders item 19.
My lord, in this case,
Yes,
state has filed an affidavit
yes.
where state has proposed some action. Now, my lord, with all sense of responsibility, I'm making this statement. Similar affidavits, I also filed as a law officer in 2008. That an Israeli firm was engaged, Tahal Construction. My lord, the end of the day, my lord, government must have the will to do the task. My lord, it's not that it's a very difficult task. There, Guwahati is endowed with natural drainage. The only thing is there to streamline. And my lord, the workmanship. Now, if your lordship would kindly consider this Diborwa Road, about 6 months back, they have constructed the footpath on the both sides. What they did in the process, the width of the drainage has been reduced, the depth of the drainage has been reduced. And end of the day, my lord, this year we had more flood. So, my lord, when you do, well, it's not that a contractor will be awarded a contract and contractor will do his job and get away. That is not how, my lord, this problem can be solved. My lord, what I'm proposing, my lord, since a lot many people came to know that I have been appointed as an amicus curiae, lot many, my lord, responsible citizens have come forward with their suggestions, which I propose. In fact, this morning and yesterday I received 3 proposals from all retired IAS officers, IPS officers. What I propose to do, my lord, within a week's time, I propose to file it in the form of an affidavit, which they have given to me. Let government also consider those, my lord. It's not that the government alone can think for the city. People have also every right.
Certainly, if the good suggestions are there.
3 suggestions have come, my lord. In fact, I'm holding those. So what I propose to do, I'll put it in the form of an affidavit.
Who will swear the affidavit?
No, my lord.
Who will swear the affidavit?
One of the person.
There is no need to file an affidavit, you file a report.
Okay,
You file a report.
okay.
That
That
these
I'll
are the suggestions which the general
Yes,
public
yes.
is giving.
In fact, this morning I have received the suggestion from a retired principal, chief conservator of forest of Tamil Nadu, who is a person from Guwahati. He has given me this morning.
Fine.
Yesterday, Bhaskar Mohanta and
Submit
Pallav Bhattacharya has also
Submit
forwarded.
those suggestions in a form of report.
Yes,
Consider.
okay. I'll do that within a week's time, you know.
And you briefly mentioned it that who the person who has given this suggestion.
Yes,
It was like,
I'll do that.
Yes,
I
Lord.
don't think so. There is no.
Yes, yes. In fact, we have also issued an advertisement seeking public suggestion.
Lordships can have the matter on next Monday. In the meantime, my lord, I'll do it.
Look here. An affidavit is filed on behalf of the Commissioner, Secretary to the Government of Assam Department of Housing and Urban Affairs, wherein the efforts for tackling the situation of flooding in Guwahati has been mentioned. Full stop. The affidavit speaks about the measures which are presently going on and are to be undertaken in future Stop. Mr. K. Chaudhary, senior counsel, amicus curiae, has submitted that he is in receipt of certain suggestions from the prominent personalities. And he would like to place the same on record in a form of a report. Stop. Time frame for this grant, full stop. This matter on and 9th of September 2024. By that date, the report may be submitted. While serving an advance copy to the state council.
My lord, 9th, I'll not be there, could it be on 5th, my lord? 5th is a Friday.
If sixth is a Friday, let it be on. If
Oh,
it is
6th
subject
is
to
a Friday.
And 6th.
My lord, could it be on Wednesday in that case, 11th?
11th.
Yes.
11th.
11th lordship, I have some difficulty. Then let it be on 13th lordship.
13th.
13th. I have to go to Arunachal on 11th. That's okay.
Deeply.
Deeply okay.
Daily list for hearing item 1.
My latest instruction says, my lord, they have, my lord, already modified the, my lord, draft, cabinet
On the last
memorandum.
occasion, you
Yes, my
there
lord.
was
In
some
fact, my lord, they
deviation from
say
the
that, my lord, the draft cabinet memorandum has been approved by the honorable chief minister, who happens to be the departmental minister, this is the home department. Now it has been recommended to the various other departments for their review, including the judicial department. So it is lying at that stage. And that is the procedure, my lord. They are working on it, my lord. They require some further time, my lord.
They are formulating a policy for that purpose.
Yes, my lord. In fact, my lord, pursuant to the order passed by the honorable court on 7/11/23.
Yes.
What will be the quantum of compensation, how it will be, my lord, computed? All this has been proposed by the Inspector General of Prisons. As per suggestion of the Judicial Department, we are working on it, my lord. They pray for some further time, my lord.
How much?
Lordship will post it after 4 weeks, my lord. We'll try our best to, my lord, complete it by.
7, we have granted you 4 weeks time.
My lord, I have conveyed, my lord, they are working on it. Just they pray, my lord, some further time, my lord. Only thing, my lord, it will have to be enrooted from all the various departments.
Sitting only till August, no?
No, no, cabinet, my lord, assembly.
Assembly.
Cabinet, it is-
Perhaps in the meanwhile, if they could perhaps, for your lordship's perusal, if my learned friend could perhaps place it by way of an affidavit, what exactly is the policy which they are, which they are trying to.
Ultimately, still it is on the
Final, my lord.
deliberated between the stakeholders.
Lordships.
Then at least wait for that. Otherwise, what would be
The second and third pair are also.
22nd on.
They submitted that the Inspector General of Prisons, Assam, has submitted the modified draft policy, which has been approved by the Honorable Chief Minister as Departmental Minister. And now and since it's a policy matter, it needs approval of the cabinet. While seeking approval of the various departments, including judicial department. Stop. It is submitted by Mr. B. Gogoi that in that process, some time will be consumed, and therefore matter may be listed after 4 weeks. This matter after 4 weeks.
Highly understand.
Deeply left. We'll have to.
Item 5.
The policy on it. Can I keep a copy of that? The thing you have to submit it. Copy of it.
May it please, Your Lordship. Well, on last occasion, Lordships asked us to take instruction from the client, whether we would like to bifurcate or rather. Well, there are two ways of looking at it. Or Lordship may decide the issue of those who have been promoted, leaving aside the thing, either to be decided separately or will come up with another appeal where the my Lord upgraded.
That your clients have to decide, sir.
Yes.
What is your instructions on that?
Well, Lord, our instruction is for the present, my Lord, Lordships will decide the appellant's appeal part, those who have been promoted.
You belong to which batch? The persons who were promoted prior to this rules of 2012 or after that?
After the rules.
After the rules, you representing those persons.
In fact, my Lord, I am representing the 10 appellants. 5 of them are promoted and 5 of them were upgraded. Appellant number 1 to 5 are the persons who have been promoted and 6 to 10 are the persons who are upgraded. Because, my Lord, the learned single judge dealt with the issues together.
Yes.
That is why we filed a common appeal.
And then there are upgradations in 2005 also, which has never
Yes.
been challenged.
That is not under.
That also has been disturbed.
That also has been
And
disturbed.
that is also a part of the appeal.
That is also a
So
part.
there are 3 different streams
Yes.
having 3
No, my Lord, initial 2005 upgradation was common to all. Both who has now earned the promotion and those who have been upgraded. Actually, my Lord, we were not a bachelor degree holder of engineering. We were diploma. Now, in terms of the central board's decision, my Lord, in administrative exigency, all the diploma holders were upgraded as assistant engineer in 2005.
that we have followed. Mr. Chaudhary, the problem is your 3 groups of clients are not standing on the same
Not
footing.
3 group, basically 2 group, my Lord.
2 groups.
Yeah.
They are not standing in the same footing.
Not, yes.
So therefore,
Therefore, my Lord, what can be done? It can be segregated. We can file another appeal for those who have
That's better.
earned the upgradation.
That's
And so far as this appeal is concerned, Lordship may treat it so far as those whose promotion has been interfered with. Within 264. Within 264 is
then you do one thing, move an application, with this effect that this writ appeal is confined to these persons and seeking permission to file further appeal.
separate appeal in respect of the upgraded. Okay.
Yes, you can move an application, you consider. Then it consider.
A week's time may be given, my Lord.
Senior concept raise some time to move everything in application. With the prayer to confine the present appeal, to confine the challenge of the improved order. Some of the appellants. while seeking permission to file a separate appeal for the other appellants who are on a different, who are placed on a different footing from some of the appellants. Good stop. List after a week.
I have. Well, I'm told these people are scattered all over the state. So may I pray for 10 days, my lord?
List after the IAS file.
Yes.
List after the said IAS file.
Item number 6.
May please your lord. This is an appeal against the order, my lord, that is page number 190, my lord.
जजमेंट है कि नहीं देखते पड़े absence ये बात जब तक burdenship पर दिया
Yes.
May please your lordships. This is an order of 22/7/2014, page 190 of amended writ petition, my lord.
Yes.
My lord, operative portion is page number 195, para 6.
Yes.
May I read?
Yes.
In the view that I have taken the punishment of dismissal from service imposed upon the petitioner by the respondent authority is harassed and grossly disappropriate to the misconduct proved against him. There is no such thing as enhance of punishment for commission of a second offense. The punishment which can be imposed upon the petitioner must be one unauthorized by the law. Since this is neither a case of willful absence from the duty nor the desertion, but an unauthorized absence occasioned by the circumstances beyond the control of the petitioner, the penalty of dismissal from service cannot be sustained in law. It must be remembered that the petitioner had voluntarily reported for the duty on 19/11/2007, which was accepted, whereupon the resumed his duty. The fact that the petitioner had been prevented from joining his duty on the ground of his illness is not disputed by the respondent authorities in their affidavit upon his subject. Under the circumstances, I have no hesitation to hold that the penalty dismissal imposed upon the petitioner is liable to be interfered with by this court. For the reasons stated, the writ petition succeeded. The impugned order dated 14/2/2008 and 15/2 imposing the penalty of dismissal from service upon the petitioner, and order dated 24/6/2011 issued by the Deputy Inspector General of Police Sector Headquarters SSB Tezpur dismissing the appeal preferring by him are thereby quashed. The respondent authorities are accordingly directed to
It was the material before the learned single judge to come to the conclusion that his absence was not willful.
Yes, sir, there is no such material, my lord. Then kindly see, my lord, he was absent from the duty from the December 2006, my lord.
16/12/2006 to 18/11/2007.
Yes, my lord.
10 months, 26 days.
Yes, my lord. There is no such material that these absence were the willful absence, my lord. Yes, my no, not the willful, my lord. Because he was ill, my lord. He was detected and jaundice, and his father was dead, my lord. And in the meantime, his father was expired, my lord. But for that, my lord, 10 months is, my lord.
unauthorized absence पता है unauthorized absence rules में short where are the rules
Rules, my lord, CRPF rule 11, section 11, my lord.
rules mention of willful
Not willful, that is absence, my lord, absence himself without leave, my lord,
Only this.
only this, my lord. That is in section 11 of CRPF rules, my lord. And punishment is also there in section 11, my lord. Punishment is, my lord, the commandant or any other authority of the officer may be prescribed, may subject to any rule made under this act, award in lieu of or in addition to the suspension or dismissal, any one of the more of the following punishment. Section 11.
Just
Section 10 M is, my lord, offense.
ये willful absence concept. Both quotation में दिया है. Most of it is voluntarily. And
what is his reply before the inquiry officer?
My lord, entering the page number. Page number 183, my lord. 183. He even pleaded guilty also for all the articles. 183. Question number 5, my lord, I plead guilty. Question number 6, plead guilty. For 3 articles, he pleaded guilty, my lord.
What are those articles?
Article in the page number, my lord. 100. 170 page number. 171 are the articles, man.
171.
171, man. Article of SARS 1. Yeah, 3 articles. He even received the rezoning notice also, my lord. Article of such 3 months.
Which rule deals with misconduct?
My lord.
Which provision in the rule deals with misconduct of unauthorized absence?
My lord, 11M, my lord. Article 1 is, my lord, 11M, absent himself without leave. That is for Article 1, my lord.
11 N of rules of 1955.
1949 CRPF Act. Section 11, Section 10 M. Small m.
Yes.
109.
Has it been reinstated or there is a stay order?
That is,
No stay order. In the
in the
meanwhile, he died, Malad. He expired.
petition,
Oh, acha.
settlement expired.
I'm represented the wife of the deceased, Malad.
Yes.
Accepted.
That is, whether you have filed any reply before the inquiry officer or somewhere,
No, Malad.
nothing.
Nothing, Malad.
In case number 185, he also, his statement is also there, my lord. In case number 183 and 182, that he didn't want to submit any document and anything.
Bring a copy of the writ appeal.
Yes, madam, case number 183, in their statement, madam. Do you want any defense assistance in helping and defending your case during the course of inquiry? Do you want to engage any person as your defense? No, I don't want to engage any person as my defense assistance. Do you want to submit in respect to any document other than those listed in annexure 3 of the SARS? No, sir.
In your writ petition,
Malad.
this para number 13. That is 117.
Okay.
That the petitioner states as against the show cause notice, your petitioner newly submitted his reply narrating the situation he faces and compelling him to remain under prolonged treatment. Where is your reply?
Reply, I am it is not enact, Malad, in the
Yeah.
petition. It is not enact.
Where is that reply?
It is just submission, Malad.
This is only a submission. Where is the reply?
Record may be called for Malad, it prevails, Malad, whether it is submitted, Malad.
In fact, there is no such order reflecting the fact that you have filed any reply to it. You have simply made a statement in your this writ petition, but where is that copy of the reply or when you put up your issues before the courts during the courts of inquiry?
Mr. Padgiri, page 117, para 13, you have made a statement in your writ
Malad.
petition. That's a
I
statement.
can, Malad.
Where is that reply?
Malad, the writ petition has not enacted that reply, Malad.
Sir, next, but at least show us the reply. Where is the mention about that reply in the inquiry report or in the order, impugned order of the discharge? Where is that? Your case before the learned single judge that earlier your father was ill and thereafter you suffered from some illness. Any document in support of that your contention? Any document? about your illness, your father's illness, any document.
In fact, my lord, repetition, it was not enough, my lord.
How the learned judges come to this conclusion that your, whatever explanation you have submitted or offered is this suitable explanation for that? Where is that, sir? What is the material before the learned single judge to reach to this conclusion that it was not a case of willful absence?
Kindly see, my lord, page 50.
Yes,
Kindly page 57, my lord.
57.
My lord. It was reflected that, my lord, about the, my lord, the doctor's prescription, my lord.
This is what
Appeal,
you have
appeal,
said, you have filed an appeal and your appeal is not
Within the
listed. The learned single judge has disposed of that writ petition and said, okay, get this appeal decided in so days.
in appeal, my lord, the doctor's prescription and certificate annexed, my lord.
After receiving the abortion while approaching towards the Rangia, my place, I lost the entire file in train. And losing a repeated time concerned lawyer put a so that the memo of appeal resultantly tendering good office because the reason they occurred delay in presenting a good office and further forwarding the same appellate authority. Appropriate and necessary orders be passed. I therefore request God to accept my memo of appeal. Sir, memo of appeal, yes, before the learned single judge, you have taken this ground. But where is that, sir? Any document, any explanation that you were forced not to join the duties on account of this, where is that, sir? Where is that? A single document. Where is the appeal, the copy of the appeal, sir?
No, my lord. That's because, my lord, subsequently after date of the, my lord, repetition, I appeared, my lord.
before the before the
No, after.
At least, sir, you should have asked for some documents. From there we gathered this, that this was even your defense before the
My lord.
authorities concerned that you failed to join the duties on account of this reason. Where is that, sir?
What is the cause of death of the original petitioner?
मला आता
What is-
due to मला आता illness madam. Due to illness, severe illness madam. From this,
What was, matlab,
subsequently died in the year 2015.
cause of death? Do you aware?
No, my lord.
How many years he had served, the petitioner?
He joined my lord July 1993, my lord.
15 years.
15 years,
So if this order is implemented, supposing,
my lord.
then his wife, widow and children will get some
Get
benefit.
pension, my lord. 10 years minimum.
Yes.
Hello.
You want-
But as per मला appeal memo filed before the मला deputy inspector general मला there is a some that मला some record submit medical report
Where is that?
मला
Sir, even you just see,
and single judge order मला based on the मला Supreme Court judgment मला
Supreme Court judgment,
willful मला desert
what Supreme Court judgment says?
मला NCC 195 reported
195,
2012 3 SCC 175
2000,
12 3 SCC
195.
page number 193. Yes, 194.
What? Page number 194.
194.
Krishna Kant B. Farmer versus Union of India.
Nothing unauthorized, like the fail to maintain duration duty. Circumstances. That's right. Compelling circumstances. What were those compelling circumstances? In your case. Now, page 187.
Well,
This is your application when you reported back on duty.
due to medical grounds,
What medical ground? Due to medical ground. Which medical ground? What are those documents? Nothing on record. Nothing. क्या काम है नहीं लिखा है years preserve the charge deduction less senior in absolute होता है तो इन दोनों में से कोई चीज एप्लीकेबल है ये काम unauthorized the deduction अरे इन दोनों में डिस्टिंक्शन क्या So that's correct. Yes. Talk. Order is that?
Item 13.
Yes.
Next. Petitioners are, appellant petitioners are recorded owners of the land in question. The land initially belonged to their grandfather. And that time, Lordship, that respondent department.
What is that? Just talking.
Look,
If you can make the government has a similar rate, no more than land rate.
Yes.
Lordship, my grandfather, Lordship, was the owner of the land. It has come to us now. We are recorded owners. Now, the respondent department, irrigation department, they approached my grandfather that they wanted some land to start an office with regard to an irrigation program. In course of time, we'll be giving compensation. He agreed. That was happened in 65. So from then onwards, they've been continuously possessing that land till date. So no compensation, nothing was done. My grandfather has gone, my father has written a letter, no response. Now, meanwhile, because of the objection we have raised, our generation, that left the land, shifted the land, they have opened an office. Government has allotted the land to start an office. But in spite of that, land has not been vacated by them. Some of the small structure they have made over the land, they're still there. Some of the utensils are lying there, equipments are lying there. Now we have filed a repetition here, stating that either you pay us compensation or acquire the land or vacate the land. That's our prayer. So when this respondent department did not file an affidavit in the matter, they're taking time. But last time when it came to the Honorable Single Judge, the Honorable Judge has held that you have delayed the matter. You have not acted diligently. It was a matter of 1965. And because of the delay, it was dismissed. Now the question is, this is a continuous.
What's wrong in that?
Lordship?
What's wrong in that?
Yes, Lordship, that's a great question. When the cause of action is continuous, then the question of delay doesn't come in. I am the owner of the land today. I find that this department is illegally possessing my land.
Sir, who is going to this verbal commitment? Where is that verbal commitment?
So let them file an affidavit. I will immediately request them. This also,
So who is now going to file an affidavit? At that time, who was the officer?
No, now they are still possessing. They have a watchman there, keeping a watchman on the land.
Whatever it may be,
Ah.
no doubt. The land, they have constructed some building or office on the land.
Not the small buildings. These are
But
small-
whether your grandfather gave this land voluntarily or on account of some assurance that compensation would be granted, from where we
That was-
ascertain all this? 1965,
Lordship.
they acquired the land.
But on
as
what
per you.
basis the government department is
And
occupying
in
my
the
land?
year 2022, you approached the court for the first time that give us the,
Question
give us
is,
the
I am,
compensation.
ownership is continuing. I am the owner. I find them occupying today.
Then file a suit for that purpose.
No,
Why
what you have
requisition?
said, that's what I,
File a suit For ejectment.
no,
If you
that
are
will
the
not
owner,
happen
then they
because
have unauthorized,
that is the right to property, my constitutional right. It cannot be taken away like that.
Okay, file an, for that reason, file an, this.
No, Lordship, kindly
compensation
peruse the
out-
judgment.
out of
Exactly
that
the same.
compensation.
Here is the same similar case, Lordship. After 38 years,
Ah.
the kindly Lordship said the judgment has just placed.
Yes,
The head note, it shall will speak about it.
and there is a series of judgment wherein they said the stale claim should not be entertained. Supreme Court judgment, series of Supreme Court.
This is also a judgment of 22. Lordship, kindly peruse the, I will head note first.
Yes,
Lordship. The right against deprivation of property, respondent state utilize the subject land and adjoining lands for the construction of road in 70 to 73. Appellants claim to be owners of the subject land. Allegedly, no land acquisition proceedings were initiated nor compensation was given to the appellant.
first of all, sir, please satisfy, is it binding? This
Yes.
judgment is binding.
That your lordship will consider, I will only placing
This judgment is binding.
because almost a
Is
similar
this
fact.
judgment is binding.
That your lordship will consider, but I am
This is
placed the
under
judgment.
Article 141 or 142.
This is under
Para 26.
lordship.
In view of the above discussion and in view of the court extraordinary jurisdiction under Article 136 and 142 of the Constitution of India. Of the Constitution, the state is hereby directed. So now this 136 and 142, admittedly, we don't have that view.
But at least something that if they. That's my, I state in the writ petition that they are taking possession of land illegally, they have not paid compensation. Let them say whether this is right or not.
But at least first of all, we should be convinced, then only we'll ask them to file reply.
Okay, I'll fix it the next week, then I'll try to satisfy your lordship in that case.
Sir, what else? This is what your case is. There is no reply. I want to satisfy.
I'll re-examine the matter, lordship, whether it is binding or not. Next week, lordship, right there.
Your Honor, yes, Your Honor. Yes, this is the editor one, the main hearing from the portion of the matter.
Loudly.
Annexure 1 and you look at annexure 1.
Annexure 1.
Yes, Your Honor. The land record, collect in 1957 to 58. Your Honor.
Annexure 1,
Yes, my lord, at page 30,
36.
yes, my lord. It is,
Yes.
they are translated that annexure, but the property total is not translated like that. I have collected some documents, man. As far documents, this land has been.
Nothing is audible. Please use the mic properly and speak properly.
My lord, annexure 1.
Annexure
Page
1, yes,
my lord, page 36, my lord.
yes.
The, at column 31, my lord. That it is not completed, not translated, my lord, page 31.
Column
No, no, my lord, column 31, page 36. This is the most relevant part of this annexure. They have not,
It
this is
says what?
relevant portion of this document.
Use the mic. It's not working.
Page 36, Montego Lordship. He wants to say Lordship. It is in the name of Jamuna irrigation from in Assamese particular, but they have not translated it.
by registered deed number so and so, my lord. Page 36. Lord. They have not translated it. One plus four column, 31 column.
What is written? Jamuna irrigation.
Yes, my lord. This one the documents I have collected. Yes, my lord. This is in the by registered deed number 6855 dated 23/10/68, my lord. This is the same, my lord. This is the same. Annexure 1 is the same annexure, my lord.
The documents are not ready, the submissions are not. What is this? बोल रहा है कि ये जवाबबंदी का जवाबबंदी का है irrigation का
Please approve annexure 1. Annexure 1 is 36.
Irrigation department has purchased that land,
Yes, my lord. I have no idea, but this is by registered deed, my lord.
registered deed.
Yes, my lord. This by registered deed number so and so is written here, my lord.
And they purchased from whom?
My lord, this the grandfather of this applicant, my lord.
Grandfather.
Yes, my lord.
They purchased this.
Yes, my lord. And otherwise, my lord, by the registered deed number so and so has been mentioned, my lord. If it is registered, my lord. It is a আপনার document. This is a documents. This আপনার documents. This is registered deed number then page number 36.
The council who engaged me is not here today, Lordship. But let it come next week. I will clarify this position.
Council?
The council who engaged me in this case, I was not there originally in this case. They engaged me for appeal. He's not today, he's gone to.
Alien lessons has already been proved, my lord. The alien lessons have already been proved. This document has been collected in 2015, my lord. Up to that stage, my lord, there is the name of the registration department is exists, my lord. Thereafter, they collected some documents whereby they manipulated the documents and muted the name of their petitioner. In the appellant in the after 60 years, my lord.
After 10 days. Nothing else there is.
Let him file an affidavit stating that, and I will also
No,
pay.
we are not, please try to understand, we are not in requirement of their affidavit.
Lordship.
You plead your case, we'll decide it.
Lord.
And if it is required, then we'll ask them. But till now, we are not in requirement of any affidavit from them.
Yeah.
Item 17.
May it please the lordship. This matter relates to the issue of attachment of the principal of Difu Government College. He was attached to the Directorate's office of the Secondary Education Government of Assam. According to them, lordship, it is a transfer, and our case is very clear. It is a case of attachment. And there was some public interest involved. That is the reason why, as a part of administrative exigency, we are not transferring him. We are attaching his service in the director's office to help the department in formulating the National Education Policy 2020. taking his experience, we are utilizing his service. The other day, I started, then the opposite party lordship made the submission that our case before the learned single judge was a case of transfer. And my learned senior friend Digonto Das, he was pleased to refer to the order passed at the interim stage, where in 2-3 places it was recorded as transfer. They are trusting on it. Now, in fact, from day one, our case is attachment, but if the honorable judge recorded it as transfer, I have nothing to say because the order, the interim order was denied to them. So there is no case for going for review also for that particular word. But if lordship is pleased to look at the final hearing order, page 22. It starts at page 18, which is impugned in the instant writ appeal, 28 June 2023. What exactly was our submission? Lordship will find it at paragraph 8, page 22.
Yes.
May I read it, this paragraph? So and so Advocate General Assam, on the other hand, submits that the notification dated 24/9/2021 has been issued in the interest of public service and in administrative exigency, attaching, the word is attaching the service of the petitioner as OSD in the Director of Higher Education Assam. The same is not an order of transfer and it is only a temporary arrangement for attachment, which is required for specific academic reason, and there is no regular replacement in his place. It is an in-home arrangement for special purpose so that the academic work relating to new educational policy and college-related works in the Director of Higher Education is properly monitored. He also submits that the petitioner has failed to re-accredit the college by NAC, National Assessment and Accreditation Council, which deprived the college from receiving grants from UGC, affecting the academic progress of the college, quality education and research activities in the college. It is further submitted that the Diffu Government College is the only government college in the district and it is the premier institution of the district. However, since the petitioner joined as principal of Diffu Government College, there has been series of allegations made against him by the faculty members and the students of the college as well as public of Diffu town regarding his arrogance and high-handed behavior. The academic atmosphere was highly affected and the teaching and non-teaching staff of Diffu Government College also submitted a memorandum to remove the petitioner from the post. The tenure of the petitioner as principal of Diffu College has been marred by problems with agitation by the students and several complaints of the faculty members of the college as well as from public for his behavior towards the students and faculty members of the college and to maintain cordial academic atmosphere in the college. The notification dated 24/9/2021 was issued, attaching him as OSD with the responsibilities of monitoring the new education policy and college-related works. He further submits that the attachment order does not amount to transfer of the petitioner from his substantive post, and therefore there is no question of the notification dated 24/9/2021 contravening the provisions of the rules of 1982. He also submits that the petitioner is yet to join to his place of posting despite the order passed by this court. So now, if we can look into the order, impugned order of attachment, which lordship will find at page 91. This was under challenge before the learned single judge. 24 September 2021. In the interest of public service and administrative exigencies, Government of Assam in Higher Education Department is pleased to attach the services of Dr. Nirav Kumar Sharma, Principal, Diffu College, Government College, as Officer on Special Duty in the Director of Higher Education Assam, and Abdul Motin, Associate Professor, Senior Most Faculty Member in the college, is allowed to hold the current charge of Principal of Diffu Government College and until further orders with immediate effect. Nirav Kumar Sharma shall draw his pay and allowances, etc. from Diffu Government College as usual. And last copy mark to serial number 7, Dr. Nirav Kumar Sharma, Principal, Government Diffu College. He is requested to take over charges OSD of Director of Higher Education, Assam, Kahilipara,
and hand over charge to senior most faculty member of the DIFU College immediately. So his substantive post remain intact. All his benefits, including his salaries, he is getting from the DIFU College. There is no separate salary head from the directorate's office. All his benefits and service conditions remain intact. Only thing is that cursory look at the affidavit filed by Karbi Anglong Autonomous Council. It was a totally unacademic condition which was prevailing. He was beating up the employees, he was beating up the students. He was inviting some extremist organization for involvement in the college affairs. All these things happened. It will start from page 109, 101. So, page 109, I'm sorry, Lordship.
So you are appealing for?
I'm appealing for the private respondent.
So it is a sixth schedule area, and education at the higher level is not transferred subject. Paragraph 6 says the secondary education, because this college also teaches 11 and 12, which comes under secondary education. The general education, that means elementary education, comes under the council. But now there are a series of litigations in between whether the council has power or not. That issue has been resolved. Now the state government has the power. There is no dispute on that now. Now, paragraph 7, may I read it? The DIFU Government College is the only government college of the district and is a premier institution of the district.
7 of what?
Paragraph 7 of the affidavit filed by Mukul, page 100, and it starts from page 109. Affidavit filed by the Karbi Anglong Autonomous Council.
Yeah.
Paragraph 9, Lordship, page 112. The DIFU Government College is the government college of the district and is a premier institution of the district. Ever since the petitioner has joined as principal of DIFU Government College pursuant to the order dated 13/1/2012, there has been series of allegations against him by the faculty members and the students of the college as well as public of DIFU town regarding his arrogance and high-handed behavior. Council has always tried its best to resolve the matter amicably to bring about a normalcy in the campus, keeping in mind the interests of the students and academic atmosphere of the college. The petitioner has also called by the Authority of Education Department of the council, who advised him to treat his colleagues and even students with respect. He apologized and even stated, "Perhaps I have made a mistake by behaving in this manner." The situation became worse when on 16/7/2013, he allegedly assaulted one of his own students just because the student dared to ask him why classes were not held regularly. After due inquiry by a joint secretary of Karbi Anglong Autonomous Council, the authority placed him under suspension and initiated departmental proceedings against him. The petitioner did not reply to the so-called notices. The Honorable Guwahati High Court by the order dated 11/12/2013 suspended the order of suspension, and the petitioner was allowed to continue as principal of DIFU Government College. In compliance of the order passed by the Honorable Guwahati High Court, the authority passed the order of 70/2014 for his reinstatement. When he was told that he could have approached the council to present his point of view and the matter could have been resolved without jeopardizing the academic atmosphere in the college. He replied, "I have decided not to set foot in the council. My only fault is that I am not a Kirby." He was warned not to talk irresponsibly and not to bring flavor of the entire incident. As soon as he resumed his duty, complaints have started pouring in again against his behavior. He filed an FIR in DIFU police station alleging that the vice principal, Sri Nobin Terang, was mastermind behind the allegation. Students protested and the faculty members revolted, leading to chaotic situation. Letters purportedly written by Ulfa warning the faculty members not to disturb the petitioner was received, and the police was informed the matter. The academic atmosphere was also completely vitiated. Teaching and non-teaching staff of DIFU College submitted a memorandum to remove the petitioner from the post. Next paragraph. After assumption of the charge of principal of DIFU College by the petitioner, the authority of the council was flooded with complaints against him. The faculty and students of Difu Government College complained against his high-handed behavior. There has been even a complaint from grade 4 employees who alleged that he was assaulted, made to hold his ears, and made to kneel down as the principal Difu Government College had overheard some trivial remarks passed by the grade 4 employee. The authority of the council called the petitioner and advised him to deal with the situation by softening his attitude towards his colleagues as well as the students. Council also placated the teachers and the students, and the matter was resolved. The deponent begs to state that without any cogent reasons, the petitioner stopped the UGC Network Resource Center in 2014 to the disappointment of the teachers and students. The petitioner also failed to reaccredit the college by NAC, which deprived the college from receiving grants from UGC, affecting the academic progress of the quality education and research activities of the college. Dr. Deepak Kumar Bora, who has been awarded SCRB project to carry out research work, has been stopped from continuing the project by the petitioner for the reasons best known to him. The action of the petitioner hindered the development and progress in the field of scientific research and brought disrepute to the college. The petitioner has not made any effort to celebrate the golden jubilee of the college in 2014. The deponent begs to state that on 19/3/2014, the teaching and non-teaching staff of Difu College submitted a memorandum to the Chief Executive Member, Karbi Anglong Autonomous Council, with a request that the same be forwarded to the Minister of Education, Government of Assam. The Chief Executive Member, Karbi Anglong Autonomous Council, instructed the deponent to forward the memorandum immediately and to place the matter before the next EC meeting. In its meeting held on 30/5/2014, discussed in detail the problem of Difu College and was unanimous in its decision that continuance of the principal as principal of Difu Government College would be detrimental to the interests of the college, and tension would damage the academic prospect of thousands of students studying in the college. The executive committee therefore resolved to release him from the administrative control of Karbi Anglong Autonomous Council. Now coming to paragraph 15. The deponent begs to state that the academic atmosphere of the college was worsened day by day due to his autocratic nature. The deponent denies the statement that for the strict discipline and a standard enforced by the petitioner was invited ad hoc teaching and non-teaching staff. The deponent also denies that the statement that the Karbi Anglong Autonomous Council has acted against the posting and continuance of the petitioner because of the strict discipline and standard enforced by him. On receipt of complaint from various persons, including teaching and non-teaching staff of the college, the petitioner was earlier called to the office of the principal secretary, but he misbehaved with the principal secretary. Also, he is an IS officer, Lordship. He has nothing to do with the council otherwise. The deponent reiterates the statement so and so. Now, next paragraph. In regard to the statements made in so and so, the deponent begs to state that the college education generally is entrusted subject of Karbi Anglong Autonomous Council. Difu Government College is also imparting education or to the students of 11 and 12, which is a secondary education. Therefore, the state government comes into the picture, Lordship. Now, coming to paragraph 23. The deponent begs to state that a large group of students gathered outside the Karbi Anglong Autonomous Council gates and demanded to meet the chief executive member and executive member in charge education of the Karbi Anglong Autonomous Council to show a student of third semester of Difu Government College, namely say Antong Ingti, who was bleeding from the ear and the left side of his face was also swollen, allegedly because of an assault by the petitioner. The deponent begs to state that the Department of College Education is an entrusted and delegated subject of the council, and as borrowing authority, the Karbi Anglong Authority has the power to place the officers of the entrusted department under suspension. But he was suspended, but they do not have the power actually. Therefore, it was a settled position that is why the earlier rounds of litigation, the Karbi Anglong Autonomous Council actually suspended him. So it was not sustainable in law. So that is why he got favorable order in those cases. Now, our case is very plain and simple, Lordship. It is a case of attachment. We are not transferring him. And in this regard, although we gone to that Madras High Court's order, but that was in relation to promotion, Lordship, not transfer. But I have got a case. Although it is not a transfer, the Honorable Supreme Court in one case held that transfer can be done to a ex-cadre post also, if there is public interest involved. But our case is on a much better footing. This judgment is 1993, supplementary 3 SCC.
Yes, that is the judgment I was.
That is a judgment. 1993 supplementary 3 Supreme Court cases, page 35. Ramadhar Pandey versus State of UP. I would like to refer to paragraph 16 of this judgment. Punjab to the attachment. May I read this paragraph also? Therefore, the appellant could be transferred as joint secretary since there is an equation of pay as well as status as is found by the High Court. More importantly, what is to be considered is whether there is any public interest involved in the transfer of the appellant as joint secretary. We have already extracted the order by which the appellant came to be transferred under clause 2B of the fundamental rules as amended by Uttar Pradesh Fundamental Second Amendment Rules 1981 provides that notwithstanding anything to the contrary contained in these rules, the governor may in public interest transfer a government servant to a post in another cadre or to an ex-cadre post. The order dated 8 July 1992 does not recite any public interest. We are also not in a position to discover from the records available before us whether the transfer of the appellant was in public interest. In the absence of a counter affidavit to or even the relevant records, we are left with no option but to conclude that no public interest is involved. It cannot be said that transfer is a necessary concomitance of every service, but if such a transfer could be effected only on certain conditions, it is necessary to adhere to those conditions. In this case, public interest being absent, the impugned order of transfer cannot be supported. In our case, this affidavit clearly substantiates and corroborates the stand of the state government as indicated in the impugned order that there is public interest.
Not this, not this. There is another judgment. I am not being able to recollect. That was a case where an IS officer was posted in an ex-cadre post. That was under challenge.
In spite of our best effort, we could not.
Maybe somewhere. But I remember having used that judgment somewhere long back.
Lot. And only on the point of attachment, I would like to refer to a Punjab High Court, Punjab and Haryana High Court judgment. Of course, it is a single judge's order. What exactly is an attachment? That is what is described here. 2003, 133 PLR, page 117. Or 2002, Supreme Court, Punjab and Haryana, Supreme, page 70, page paragraph 8. May I read paragraph 8, logic? Internal page will be 5.
Yes.
In this writ petition, the petitioner has also tried to assail order annexure P16 by which he has been attached to headquarters 615 Independent AD Brigade, which contravened the provision of para 453 of the RA. The objection of the petitioner is that the transfer of a personnel from a command before completion of the disciplinary case is not permissible in view of this para. This objection, to my mind, is unsustainable on 2 grounds. Firstly, because the order talks of attachment with brigade, which by itself does not amount to transfer of the personnel from his unit of formation. According to Reader's Digest Universal Dictionary, the word attachment means to assign personnel to a unit on a temporary basis. In central distinction with this, transfer has a sense of permanency about the change of location, place of posting. Looking at idiomatically, the permanency in the shifting. In the seen in this context, the attachment does not amount to transfer and Therefore, there is no question of the order contravening the provision of paragraph 253A, and therefore the objection is unsustainable. A perusal of paragraph 2, which reads as under. So that I am not. What I am trying to emphasize is that transfer and attachment are two different components, two different events. And here, Lordship, nobody is replacing him. There is no other person who has replaced him as a principal. The senior most of that department was given to act. That is not a, and on top of that, that gentleman has also retired. Then now the present one, another senior most person is manning that post. And lastly, my submission is that as because he is before this honorable court, which is a court of equity, when there is a specific order, paragraph of the impugned order, of the interim order passed by the learned single judge, page number, page 128. When the interim order was denied to him, in paragraph 10, the learned single judge very categorically directed him. May I read this paragraph? In light of forthcoming Durga Puja festival, this order was passed sometime in 2021. Just 1 second. It was passed on October 8, 2021. In the light of forthcoming Durga Puja festival, the court is inclined to provide that in the event the petitioner makes a representation to the respondent number 1 for granting him some time to make arrangement to join his place of posting, the respondent number 1 shall grant at least 14 days time to the petitioner to join his place of posting without any coercive action till such time. The refusal of the interim order does not preclude the right of the petitioner to submit his representative before the competent authority against the attachment order in the Director of Higher Education, by so and so. So he was in here, paragraph 10 very clearly says that he have to join within 14 days. So after more than 2 years, on 28, after more than 2 years, he resumed the service. So 2 years, he did not join.
SLP was preferred against this order.
No. SLP was preferred against because ultimately the division bench order. This honorable court granted a stay of the learned single judge's final order. So my humble submission is that when this handle was given to him to join within 14 days, the direction, in other words, if you go, he went to the Honorable Supreme Court against the order of 12th October 2023, when this Honorable Court granted a stay of the learned single judge's judgment. The SLP is dismissed as not pressed. So when it was about to face dismissal, they withdraw it. So he is not listening to the government. He is not listening to the council. And finally, he is not listening to the learned single judge also.
That is over now. That is over. Now he has joined pursuant to the division bench order. That is over.
Now, for 2 years, had it been like this, or if a government officer did not obey this honorable court's direction, the contempt would have followed. We cannot file a contempt case against that, Lordship. That is why we did not file. But the thing is that is the arrogancy. That is the audacity. So we cannot, as a government, Lordship, allow an institution to suffer because of a person who is not fit to be there. He is beating the employees, he is beating the students, he is inviting extremist organizations for the affairs of the college. He is not taking steps to celebrate the 50 years. It is a big occasion for the college. He is not taking steps for getting the accreditation from NAC, as a result of which the research work suffered. The other activities regarding education prosperity suffered. The whole ambience, whole academic atmosphere is vitiated for one single gentleman. And he is trying to give a color of Kirby, non-Kirby. All the persons who are manning.
Yeah.
So he is trying to give a communal color, but the persons who actually acted in his absence are all non-Kirby people. The institution is not like that. There are ample number of non-Kirby students, ample number of, in fact, majority of the teachers are not Kirby people. So this is my humble submission, Lordship. In greater public interest, we have issued this order, nothing personal, and there is no violation of any law because he is not transferred. We are making a stopgap arrangement so that the institute suffers, institute don't suffer, and the student gets proper ambience for their academic exercise.
Is this a stopgap arrangement till he retires
Yes,
or
Lordship. Yes,
there
it
is
is
a
a stopgap
possibility that?
arrangement because we are now trying to take his.
How much time this stopgap arrangement?
Lordship, because we are in the process of implementing the national education policy, it will take some time. It is a gradual process.
He's assigned to do some work on that?
Yes, we are giving. That is why, that is the core area where the implementation, the ultimate NEP will get fully implemented by the year 2034. 14 years program, Lordship. But Assam will not take that much.
Okay.
Deeply obliged, Lordship.
Mr. Advocate, it's a case of attachment, not a case of transfer.
Yes, Lordship.
Simple a case of attachment.
The Lordship, initially, Lordship, when the matter was argued, in the affidavit also, the stand was not very clear. It was, yeah, now later on, Lordship, when the final argument happened before the learned single judge, of course, they argued morely on the attachment. So I'll address on this only, Lordship. But like before, because my learned friend, Advocate General has argued that he has been brought as an attachment to look after the matters relating to national education policy. So, Lordship, since he has concluded with that, in fact, Lordship, we have filed an affidavit in this matter, Lordship. Filed an affidavit, and in the affidavit, we have annexed a certificate. Certificate issued by the Director of Higher Education, Assam.
Yeah.
Where he is working, Lordship. He is presently working. So, Director has issued a certificate saying that no works.
Page
Lordship, page 137.
137.
Yes, Lordship.
Yeah.
So it's a certificate issued to him. We thought because there was a contention that like he has been brought for national education policy, so we have brought this certificate of record, Lordship. So I'll just read out the certificate, Lordship. Page 137. This is to certify that Dr. Nirav Kumar Sharma, Principal, Diffu Government College, Diffu, has been serving as OSD to the Director of Higher Education in the Directorate of Higher Education, Assam, Kahilipara, since 30/10/2023 till date. His substantive post is Principal, Diffu Government College. Now he has been working in various capacities in official works in general branch like roster preparation, resolution, disciplinary procedure related, career advance scheme promotion, court matters related to appointment, etc. Appointment, college establishment branch, planning branch, and other allied works, excluding NEP and account section. His performance is satisfactory.
So you are doing some work.
I'm doing some work, Lordship, but Lordship, this person who is a graduate of Delhi University, he went to BHU for PhD. He came and joined as a principal in Diffu College. Lordship, his ambition was not to do clerical work, Lordship.
Atmosphere of the college.
Lordship, he's
The
Lordship.
atmosphere of the college.
No, Lordship, that is why.
Then why not having to remain on the same set post?
The
The
Lordship-
people are not comfortable, the students are not comfortable, the staff is not comfortable. all other.
Lordship,
persons
those are,
not
Lordship,
comfortable, then why are you insisting upon that?
the irony is that, Lordship, those are only allegations and we have replied to those allegations. We have specifically replied to those allegations. As far as Kirby, non-Kirby, Kirby, tribal, non-tribal things, those were never said by this person. Those have been replied to by us in the petition stage itself, Lordship. And if there are certain things, there are certain allegations against me, those could have been inquired into. A DP could have been drawn, I could have been dismissed, I could have been transferred, I wouldn't have minded it. But why this way, Lordship? I have joined after the APSC appointment, I have duly selected.
No,
I have
we
duly
are not questioning that.
correct, Lordship. So one thing is that, Lordship, I joined as a principal. I wanted to further the education. I was not supposed to work as a clerk in the government department. So,
Mr. Kalita,
Lordship.
you see, the details we have already seen.
Lordship.
Their version, your version, these are all fine.
Lordship.
But tell us, what is the fundamental argument on the legal principle?
Yes.
Please understand.
Correct.
Their fundamental argument is that this man has not been transferred. Forget what has been projected in the order of the learned single judge and whatever has happened. The state stand is that this person, while serving as principal, was vitiating the ambience, the atmosphere of the college. These are some of the facts which they have brought on record. So one option was obviously to suspend him, draw DP. Instead of doing it, keeping in mind his expertise, his educational background, they have decided to entrust him with a different work as an OSD, which according to them is not a transfer. It does not involve violation of any of condition of service of the petitioner. And at the same time, he is being able to do some substantive work. Therefore, according to the government, this is a decision taken in public interest and it does not violate any of the provisions of the rules. If you cannot counter their argument on legal front, we will allow the writ appeal. And you don't have much time to do that.
No, yes, Lordship.
Because what has happened, where he is educated,
Much
why
time.
he has come, what is his
Correct, correct.
idea, we are not concerned with that.
Correct.
We are only on the legal principle.
Correct. Now,
So
Lordship, yes.
if you can punch a hole in this argument on the legal principle,
I'll
then
do
it's
that.
another matter. Otherwise, we have no option but to allow the writ.
No, I will argue on the legal principles only, Lordship. As far as my limited knowledge goes, there are two principles whereby the service jurisprudence governs. I mean, a person can be shifted from one place to another place if he's a government employee by two ways. One is the transfer, which can be done as per the rules and regulations which prevails as far as the person is concerned, and secondly, by way of deputation. Now, as far as attachment is concerned, in the relevant rule, there is nothing called attachment. There is nothing like a definition of attachment is given there. So how attachment will be treated? Now, there is a case from this Honorable Guwahati High Court also that attachment is basically in the nature of a deputation. And if deputation happens, then what are the norms and what are the principles that has to be followed? That has to be seen also. Now, if
Deputation will involve a borrowing department and a lending to the main department. Minus that, there can't be any deputation. So whatever is there in that judgment, we will not go into that. But you have to show how your fundamental right has been violated.
yes, Lordship.
Minus that, there is no question.
Lordship, kindly allow me 2 minutes time. Lordship, if it is a deputation, if
It is not,
if it is a deputation, what is attached? What is attachment? Where I could not find anything called attachment other than this Guwahati High Court judgment, Lordship, which we have already placed, wherein it has been stated specifically that attachment is kind of a deputation. That case law we have already placed there, Lordship.
Which is that?
I'll just please.
This state of Arunachal versus this Brajendra Pratap Singh.
Yes, Lordship. Yes, Lordship, presented for the same Lordship.
Para 38.
Yes, Lordship. There are 38 Lordship. It's regarding OSD Lordship. Then another case. So paragraph 38 Lordship makes it very clear. Lordship.
This OSD
Yes, Lordship.
is an ex-cadre post.
Yes, Lordship.
An employee can be resigned without his or her consent.
Correct, Lordship.
How can it be? Transfer of a person on an ex-cadre basically can only be on deputation. If he has sent his deputation, his consent is required to be applied.
Another case from Manipur is also there, like a similar language.
This post of this principal comes under this directorate.
Lordship.
The post of this principal comes under the directorate only.
Higher education. You know.
Higher education that this
Yes, higher education.
higher education.
Yes, Lordship.
So you are on the very same, in the very same department.
No, Lordship, only thing is that, Lordship, I have been working there from 2015.
Yeah.
So there was no allegations after 2015. The allegations happened, Lordship, when there was the introduction of biometrics of entry and going. After that, there was no, as far as like the public interest aspect, which has been argued.
Mr. Kalita, all allegations against your client is wrong. Let's presume it. Still then, what is the fundamental principle on which you are basing your case?
I'm basing my case on this, Lordship, that in service jurisprudence, a shifting of person can be done two ways. That's what I have found, that one is by transfer, another one is by deputation.
Shifting from where to where?
Shifting from one department, I mean, if it is an inter-department transfer, and then also, and otherwise also,
Department deputation.
no, not deputation, transfer. Shifting transfer, I'm talking about transfer, and if outside department, then it can be done by way of a deputation. So if it is not deputation, then it had to be a transfer. Their cases, it is not a transfer at all. So they have now argued that it is an attachment. Now, I could not understand what is attachment. Attachment, I found, and as for my this thing, Lordship, my humble submission is kind of a deputation. And if it is a deputation, then the norms of deputation has to be followed.
It's not deputation. Deputation has to have a borrowing department and a lending department.
Yes,
Without
borrowing
that, there cannot
department,
be-
lending department, and the employee. And there has to be a consensus of three.
But which is the borrowing department here?
Here, Lordship, it has been, this is
Which is the borrowing
the-
department?
This is, Lordship, a principal is a single career post, Lordship. It's a single career post.
No doubt.
In
But department, which
So
is the
it is
department?
not transferable. That has been already settled, Lordship, that it is a non-transferable post. It's a non-transferable post because the rule was, when amended, it was challenged. And that rule was.
Mr. Kalita, we are repeating it again so as to give you an opportunity to address the court.
Yes, Lordship, yes.
All these are irrelevant in this case. You may argue for the whole day, but it is not going to make any difference. You have to show us how the order passed by the department is violative of your fundamental rights or rights crystallized under the laws framed under the Constitution. If you fail to show that, we'll set aside the order of the single judge.
No,
If you can show that, maybe
No,
you have a case.
Yes, Lordship, my humble submission.
You have to
is-
address the court only on that,
Yeah.
nothing else.
Well, I am also just pointing out only on one thing, Lordship, that attachment is a way of, is a kind of deputation. That's what I have found.
Let's assume it is.
So if
How does
is-
it violate your fundamental?
If it is a deputation, then my consensus is required. That has been, Supreme Court has stated so, that it has, specifically Supreme Court in several judgment has stated that if it is a kind of a deputation, then consent of the person is required. And in this case, Lordship, I have not been consulted. I was working as a principal. Now I have been compelled to work as a clerk in the department. How it is, why is my fundamental right is not being violated, Your Lordship, then?
If it is deputation. If it is not deputation, then
And my argument will be it is a deputation. Lordship. As far as case laws that I have found, it is a kind of a deputation.
same department. So therefore, your argument is that because it is a single cadre post of principal, the government by attaching him, although within the same department, this shifting amounts to deputation.
Correct.
Because it is a deputation,
Correct.
it could not have been given effect to by without consent.
Correct.
And therefore it is a violation of your right.
Absolutely.
That's your only argument.
Absolutely. That is the only argument. If it is not, I mean, it is, if I could not convince on that, I don't have any case. And Lordship, as far as deputation is concerned, Lordship is Lordship is aware, there are several case laws that consent has to be taken. Several case laws are there. And in this case, Lordship, as far as I have done little bit of whatever, in my capacity, some research work, I could not find any case laws, any ratio decidendi or attachment, or rather the definition also, as far as service jurisprudence is concerned. So Lordship, if it has to be done, it has to be done in two ways. One is transfer, which they have not argued. And the second is attachment. And if it is an attachment, it has to be by way of a deputation that they haven't done. They could have taken me by way of a deputation, Your Lordship. They could have done it, but they haven't done it because they could not transfer me. Because they are aware that I could not be transferred because rule bars it. So there is no other way, so they have to attach me. And now what they are doing, Lordship, I have been given some works which is not at all related to new education policy, Lordship. Where is the public interest there?
The
order on the face of it
If
violative.
if we direct them to assign you a work of national education policy, you will be happy.
No, that's, that's,
Ask them.
the lordship, in the face of it, lordship, this attachment order is illegal. lordship. I mean, he has joined through APSC, he wanted to become a principal, lordship. He was an educationist, lordship. And he's a strict disciplinarian, he's an honest person, lordship. He's not, like, kind of allegations are coming, those are very, morally very, this thing, he's also feeling low about this because he never, went for this kind of things. He never thought that this kind of things will happen to him.
You are alleging malafide.
We have in fact replied all these
Are you
allegations.
alleging malafide?
There are,
Against whom?
What?
there are. There are.
Why you have been suspended in between? Though by a authority who is not competent, why you have been suspended?
For the same reason, lordship, what has happened? The biometrics have been introduced. Let's explain it.
Only on account of this biometrics. You have been
He's a
suspended.
strict disciplinarian. First, he's an honest person. He did not want students to roam around here and there. He did not want the staffs to go at 12 o'clock. Because in the DIFU college, DIFU is situated in such a place, there are a lot of professors and teachers. They go out from different places. They do not stay there. The principal stays there. So like person like not attending the classes, they got little bit, as usually happens in human relations, let's say, that has happened. And like he was trying to control the students there. And he was not going to, not meeting any people there, officers there. Those are the things like, that has
It is
brought in rut. And
It is
that's
not-
why
not
from the
a-
very beginning, Lordship, from the very beginning, they were trying to oust him. Initially, they filed a PIL was dismissed. Then they wanted to transfer me. I have been reinstated because they didn't have a power. Then they tried to release me. That has been also stayed by this honorable court. This matter is still pending. They have been doing this, Lordship. And I have been bashed inside my cabin by gundas and ruffians and like including the teachers. And teachers' names were also there in the FIR. All these things, Lordship, we have replied to. He has been bashed inside his office. He had to be hospitalized.
Then why do you want to go back?
Lordship.
They are protecting you.
Lordship, I have joined as a principal. I wanted to further the education there. And this college was run very nicely after 2015. Only before 2015, this incident happened. From 2015, nothing was going wrong. But I don't know what was the reason behind them to take me away from them.
His retirement is due when?
It's a 2024, 27. It was 27.
27.
Most probably 27.
26.
26. So in my humble submission, Lordship, this is a kind of a deputation and the order has been passed, though by way of stating that it is an attachment, but it's a deputation. So if it is a deputation, Your Lordship, that order could not have been passed.
Only one point I'd like to, in our affidavit, we say he would be entrusted with work relating to education policy and college-related works, number one. So college-related works he is doing. The other part is, Lordship, he is working, when he was working as a principal, it is not a teaching faculty. It is administrative jobs. The job of a principal is totally administration. And here he is doing the same work relating to other colleges other than DIFU College. So both the work either in DIFU or as well as in Guwahati, he is doing administrative work only. In the principal post is not teaching post, it is administrative post. Highly obliged.
Obliged.
Item 18.
Yes, Lordship, may I please, Lordship, the short question involved in this case is whether the respondent number one appointment on deputation can be treated as a promotion or not, and the tribunal has directed to be treated as a promotion. Now, Lordship, may kindly come to the advertisement at page 21, Lordship.
Yes.
Lordship, may I read from the left-hand column, Lordship. Application are invited from eligible candidate not exceeding 56 years of age with a requisite qualification for filling up the following post on deputation basis under debt recovery tribunal.
Ministry of Finance, this, okay.
Ministry of
applications
Finance.
are- Yes.
Department of Financial Service, Debt Recovery Tribunal, Guwahati.
Yes.
Section officer, we're concerned with section officer, Lordship.
Okay.
And for note, Lordship, note number 2 will be, that is what the tribunal interpreted. For the post of section officer, departmental candidate having requisite qualifications shall also be considered along with outsider. And in case the departmental candidate is selected, the post will be treated to have been filled up by promotion. Now, Lordship, the relevant point of time, respondent was working as an assistant at the DRT Cuttack.
DRT?
Cuttack,
Katak.
Lordship. Now, Lordship, next page 22, here's his appointment order. May I read, Lordship? Page 22.
Yes.
The Sri Bansidhar Mahapatra, assistant of DRT Cuttack, is hereby appointed by the approval of the Honorable Presiding Officer of this tribunal to the post of section officer in the pay band so and so in DRT Guwahati for a period of 3 years on deputation basis. So his appointment was, Lordship, very specific, for 3 years on deputation basis. And he joined, Lordship. Next page, Lordship, 23, he gave an option to draw deputation allowance, Lordship. To the so-and-so subject exercising option to draw the deputation allowances plus scale of pay of the so-and-so. It is humbly submitted that consequent upon my selection to the post of section officer on deputation, I have reported my joining as section officer at DRT Guwahati on so-and-so.
And he was working as section officer in DRT?
No,
Katak also?
assistant, as an assistant.
As an assistant.
Assistant, Lordship. Now, Lordship, without going to all these 2 points, that will make it clear. Lordship, may kindly come to the page 24. Prior to that, Lordship, 2018, each of the DRT has his own rule. Now, Guwahati rule is, Lordship, this rule may be called debt recovery tribunal. There is a typographical mistake stated, number 2, Delhi, it should be Guwahati, because I have annexed the hard copy also, Lordship. Hard copy is at page 32.
In exercise of central government hereby.
So each of the DRT has his own rule. Now, it was in 2018, all the DRT were clubbed together and this rule was framed, Lordship, at page 40.
40.
40. Prior to that, Lordship will find at page 36. The last at the bottom, Lordship, section officer. There is only one post. This is related to DRT Guwahati. There is only one post, Lordship. And after this, all are amalgamated and new rule was framed at page 40, Lordship. Lordship will find this rule is called in exercise of power conferred under section 36 of the recovery of debt due to financial action. Number 1, debt recovery Kolkata. Number 2, debt recovery Kolkata Group CD. Then all these, Lordship, Hyderabad, Guwahati is a serial number 14, page 41. Then Kotak will also will find at page 42 at serial number 41. So all these were clubs and now the cadre strength is 10. Lordship will find at page 43. Section officer is serial number 4, Lordship. So only after 2018, anybody working under the DRT Appellate Authority Kolkata will be treated as, can be treated as a departmental cadre, not prior to date. This advertisement is of 2015, Lordship. Now, Lordship may kindly come to Section 3 of the DRT Act. DRT Act to do. Yes. अच्छा मुझे तो घेरी है I have a lordship. Lordship may take this, lordship. It was Section 3, lordship. Establishment of tribunal, lordship. Yes. May I read, lordship? The central government shall by notification establish one or more tribunals to be known as the Debt Recovery Tribunal to exercise the jurisdiction, powers and authority conferred on such tribunal by or under this act. Subsection 2, lordship. The central government shall also specify in the notification referred to in subsection 1 the areas within which, lordship, this is important, within which the tribunal may exercise jurisdiction. Now, DRT, Guwahati, lordship, exercise jurisdiction. I have the notification, lordship. So this perhaps in the record, I submitted earlier also. I am again, lordship. The column number 4, lordship. Jurisdiction. State of Assam, Meghalaya, Manipur, Mizoram, Tripura, Arunachal Pradesh, Nagaland, and Sikkim. This Sikkim was added later on, lordship. So, Cuttack was not within.
Mr. Chakra, what is your case? What is the formulation?
My case is it cannot be treated as a departmental candidate.
So he was appointed for 3 years on
3 years,
deputation.
now, man, he should go.
3 years is over.
Over, lordship.
Then what is the problem?
He approached the tribunal and got his order in his favor, lordship, to be treated as promotion. He cannot be a departmental candidate.
But what kind of a advertisement note is this?
Lordship.
Will be open selection treated to be promotion. It's a totally self-contradictory position.
Lordship.
What are these people doing?
No, lordship.
How can it be open selection
now,
and promotion?
Now he will get the promotion, lordship, because all the person immediately above him and the immediate junior has now been promoted as section officer. He will get the section officer.
Where?
Lordship, I have that.
Will you get this section officer post here in Guwahati or in Cuttack?
Now, lordship, anywhere within this jurisdiction.
Yes, sir. What do you mean by anywhere?
Lordship will find the promotion. Lordship, this list will make it clear, lordship.
Will be promoted where?
He can get Guwahati also because nobody is.
Also, sir,
He is occupying the post at Guwahati, lordship. He can be treated as Guwahati, but that will be from.
Promote him.
Close the matter.
From the date his immediate junior and immediate senior has been promoted. That if the observation is there, lordship.
Immediate junior or senior, what do you mean by immediate junior?
Lordship, serial number, his position is serial number 5.
Yes.
And serial number 4 is promoted on 25/11/2020. So from that date he will get.
You do the exercise and place it before us, we'll close the matter.
He was sent on deputation when he was sent on deputation in 2017.
2017.
Okay, now you say that we'll promote him from 2020.
20, lordship.
Yes, Mr.
Lordship, I want to place few paragraphs of Planet Tribunal's order. Page 148, paragraph 15, 16, and 17.
You don't want promotion.
No, Lordship, I want promotion, Lordship.
Yeah, let them promote you.
No, Lordship, that is there. I'll definitely after 2018 rule I am entitled to. But Lordship, may please to see paragraph 15, 16, and 17, reasoning given by the tribunal. And similarly situated person, although it was in another cadre, he was also, advertisement was for deputation, but he was treated as a promotion Lordship. And this honorable court by order dated 28/6/2023 asked the department to produce record with respect to that. Why discriminatory order?
Mr. Kail, the reason we are saying this, there is a fault in the drafting of the advertisement, according to us. Deputation and promotion are two different things.
Yes, Lordship.
But if we go very deep into it, it might go this way or it might go that
No,
way.
Lordship.
You want to take that chance?
Yes, Lordship.
Huh?
Yes, Lordship.
We might hold that it's deputation.
Yes, Lordship.
And then nothing else will be given.
Yes, Lordship. Lordship, we come to paragraph 15, 16, and 17 at page 148.
Yeah.
From the period of the above, the rule vis-a-vis the recommendation of the presiding officer, who at the relevant point of time was the appointing authority and made it clear that the applicant was appointed on deputation basis, since one writ petition supra was pending at the time of appointment, and for long time the aforesaid post of section officer was lying vacant due to non-availability of appropriate person. However, after promulgation of 2018 rule, all the DRTs were put under single rule to avoid any confusion, wherein he has been specifically provided that the departmental category who are in the direct line of promotion shall not be eligible for consideration of appointment on deputation vis-a-vis. A deputy shall not be considered as eligible for consideration of promotion by promotion. Paragraph 16, it is observed that the applicant was appointed in such a time when the equipment rule was under process and changed after considering the factual difficulty to promote appointment on deputation within the different DRTs. However, if the contention of the respondent has to be accepted that the applicant was appointed under Rule 2001 of DRT Guwahati, in that case, the presiding officer, who is the authority who has to decide whether applicant would be treated as promotion or in deputation, or in the instant case, said presiding officer, after withdrawal of the writ petition by one incumbent, namely Holiram Das, was of the opinion that the applicant to be treated as promoted. Even then, the subsequent equipment rule also has made clear that the employees of all the DRTs under the same roof department may be placed in different places, but would have been treated as promoted. In the instant case, K. Mukherjee, Supra also the finance ministry had applied for the same analogy and had treated said K. Mukherjee as departmental promoted, though he has come from another DRT and for a different post. It is further observed that the applicant is guided by Rule 2001 of the DRT. In that case, the presiding officer is the authority to decide, and the chairperson of DRT, who became appointing authority after promulgation of 2018 rules 2018, has no authority over this issue, which has come into existence after appointment of the applicant. Admittedly, applicant was working as assistant in DRT Cuttack, but applied for DRT Guwahati, and both the DRTs are under the finance department and Group B officers of the DRT. Therefore, working in different places cannot make him out of the department like any other department of the central government or the state government. Therefore, in our considered view, the selection and appointment of the applicant to the post of selection would be treated as promotion instead of deputation with all consequential benefit. However, if the applicant has already availed deputation allowance, he is therefore liable to refund back the said amount, or it can be adjusted from his consequential benefit. Now, Lordship, we have filed out.
As promotion only for 3 years.
No, Lordship,
Not beyond that.
my contention is that I'm working in the DRT Cuttack, Lordship, and all the DRTs under the finance ministry, Lordship. And this honorable court filed admitting the petition by order dated 28/6/2003, directed the respondent. I'm reading, Lordship, this is a 4-line order. Further, counsel for the writ petitioner shall obtain instruction with regard to why a different stand is being taken by DRT Guwahati, while the respondent case had been decided in the same line as has been decided in the case of K. Mukherjee by the finance ministry, which is reflected in paragraph 16 of the imperial order. And Lordship, please to see the advertisement of.
I have brought the records.
Lordship, record was called for this just to ascertain the notification on the notification, how this tribunal was constituted.
Record is
That notification I have given. Only so far as K. Mukherjee, Lordship, one instruction or sort for, I'm placing the instruction, how it can be differentiated.
It's page 176 of my affidavit, Lordship. The advertisement whereby the Mr. K. Mukherjee was appointed.
That was also for 3 years.
No, Lordship K. Mukherjee was working at the DRT Calcutta, Lordship. He applied for absorption. A DPC was constituted and the his parent department gave NOC. Thereafter, he was absorbed. Thereafter, he applied for through a regular selection at recovery officer at DRT Guwahati, and he was appointed by Ministry of Finance, not by DRT Guwahati or DRT Kolkata. Recovery officer appointed Ministry of Finance. And he never applied for absorption. He never applied, Lordship.
He
In
was
that way,
sent on deputation in 2017.
Lordship.
And this
And
all the DRTs were merged in 2018.
18 only, Lordship. From 18, he can be considered as a departmental candidate, not prior to that, Lordship.
Lordship, please take up page 176 of my affidavit. 176 of my affidavit.
176. What's it say?
By which the advertisement is called for building up the post of debt recovery officer. Page 176.
Yeah.
This is the Government of India, Ministry of Finance, Department of Finance Services, filling up the various posts of on deputation basis in debt recovery tribunal, DRTs and recovery tribunals, DRT under Department of Finance. First, Secretary Registrar, 2 Assistant Registrar, 3 Recovery Officer. Mr. K. Mukherjee applied for the Recovery Officer.
Mr. Kayal, are you submitting on instruction when you said no to their offer to promote you with retrospective
That
effect?
Lordship, automatically I will get by after 2018. By rule 2018, automatically Lordship, the department is to give me that promotion. Lord.
So
My case
you
is
want your promotion be treated from the date when you were sent on deputation.
yes, Lordship.
And not from 2018 or 20 or whatever it may.
Because I lose my.
It appears to be somewhat difficult because
4 senior persons are already there at that time.
No, Lordship,
the persons who are senior to you, since because if some section officer has not applied for deputation for whatever reason, he don't want his deputation to another place, then he would be deprived from promotion, though he is senior, and you would be treated as a promotion, promotee.
No, Lordship, because I applied on the basis of the advertisement, Lordship.
Yeah,
I applied on the basis of the advertisement.
advertisement you applied.
Yes, sir.
Suppose there are 3 officers. 2 of them are senior to them, senior to you. They have chosen not to apply for the deputation because they are happy where they are. Then, since you were selected on deputation or sent on deputation, you will be treated as a promotee. How can it be?
Permanent basis.
Without or ignoring their seniority.
Lordship, they were not the assistant working at the relevant time. That is also, that was not considered by the department.
Sir, we are giving this a situation which may not be here, but suppose in case 5 section officers are there, you are at number 3, and advertisement inviting applications on deputation. You applied for deputation. You that application is allowed, and you were sent on deputation to whatever another DRT. So you are trying to say that that is a promotion overlooking their seniority of 2 other persons.
No, Lordship, here the situation is different.
Here in this anti-corruption department, so far as I am not concerned here, but in this Rajasthan, the police officers are on deputation in the anti-corruption department on a higher post. And soon their term is complete. Again, they'll revert back to that lower post. Suppose there is a deputy superintendent of police, he is absorbed as sent on deputation with the ACP on additional superintendent of police. Soon his term is expired. Again, he revert back to the post of deputy superintendent.
What I've Lordship stated, that is different situation, but in this case, the situation is entirely different, Lordship. And Lordship
can't be treated as a promotion, even though there is a It's mentioned in the advertisement, that is altogether against the service jurisprudence.
How does he explain the order itself says for 3 years?
For 3 years, then what happened after that 3 years?
I'm still working, Lordship, because
You are still working,
order of
but after completion of that 3 years, though, for that period you will be treated as a promotee. But after 3 years, when your deputation term expired, you'll again required to go back to Cuttack.
yes, Lordship, that is in that
Then
situation.
your 3 years are now complete.
Look, after 3 years I've completed, I approach that Lordship, in this case, what happened?
Then go back to the Cuttack as a section officer.
No, Lordship, because rule was amended in 2018. Whether I
If
will,
you are ready for this, that day before that, day on your seniors were promoted, you'll also accord, they'll
Even from
also
18.
accord you.
When the composite rule came, from that day they are willing to consider it.
They're willing to consider, but certainly not before promotion of the senior
seniors.
officers.
no, definitely,
Lordship, he himself admitted at page 76, while working at DRT Cuttack as assistant in his parent department. That is his statement in the way.
see what happened, the presiding
You are
officer.
ready, seek your instructions, you are ready to have your promotions from the day your seniors were promoted.
Lordship, may take up after tomorrow, I'll, because he is here only, or tomorrow, Lordship.
After tomorrow, then only they'll record his statement that they'll grant you the promotion from this date,
From this junior has been,
from this, the senior persons were promoted. From that date, you can claim your promotion on the post of this
Section officer.
section officer.
I'll, Lordship, may take after tomorrow. I'll-
After tomorrow.
Lordship.
Yeah.